At the beginning of February, I did a video on an adoption case that was on its way to the Supreme Court. In it, white foster parents proclaim they should have precedent over Native American people when it comes to adopting their children. The idea is inherently racist. The current law under the Indian Child Welfare Act of 1978 states that any Native American children must be placed with a family member first, a fellow tribe member second, and if failing that, another family, which means a non-Native family would actually end up being fourth on the list. This appears to be unacceptable to the Brackeen family, who have essentially declared this law supporting Native Americans to be racist. Of course, they're not overtly saying that. They're just claiming that it violates the Equal Protection Clause of the 14th Amendment because of the race of the adoptive parents, and thus discriminating against them. Citing the Equal Protection Clause of the 14th Amendment, the plaintiffs claim that the ICWA violates their constitutional rights by discriminating against them. Of course, the claim of racism itself is actually racist. The entire point of the legislation is to protect Native American culture from destruction, a destruction that has been wholly deliberate. The ICWA law was created because a third of Native children at the time of the creation of the legislation had been removed from their families and sent into white families. Often very prejudiced justifications were given for their removal. Combined with the history of assimilation and cultural genocide, the necessity of such a law should be very obvious. Essentially, what we have here is a white couple who feel that they should be placed above a protected group of people, a people they think that should be made subordinate to them. This is how it was explained by Rebecca Nagel of The Atlantic. In the late 19th and early 20th centuries, the federal government ruthlessly separated Native children from their families and sent them to boarding schools. There, they were stripped of their clothes, given English names, and punished for speaking their language, and they faced widespread emotional, physical, and sexual abuse. Today, where many of these children are buried, is a subject of federal inquiry. The justification for boarding schools was that Native people would achieve equality in the United States only if they assimilated into white society. Boarding schools would help Native children be more like white children through assimilation, but the schools also served another purpose. At the same time, the U.S. wanted to privatize tribal land and open up big areas to white settlers. In the pressure campaign, Native children were bargaining chips. The children would be used as hostages for their good behavior of their people. One U.S. official wrote at the time, and it worked. When the Lakota and Dakota leaders agreed to land cessions in 1889, they acknowledged that losing their children had driven them to the bargaining table. And it seems that really nothing much has changed in this case. The more things change, the more they stay the same. Aside from the adoptive parents, there's a very real struggle here to undermine the Native American sovereignty that has very little to do with this child. The pro bono lawyer for the Brackeen family, Matthew McGill, has a history of anti-Native American lawsuits under the firm Gibson, Dunn Crutcher, LLP. It has a long history of attacking Native rights in court. They've also worked for Amazon, Chevron, and Walmart, and most importantly, the Dakota Access Pipeline. So you can see where this is going. In the past, the law firm has represented the gaming industry in a suit to break up so-called Native monopolies on gaming using the same race-based argument. We're looking at an attempt to undo all of the protections and guarantees made for the most marginalized group of people in the entire United States. There's an effort to delegitimize the Native American struggle for the sake of profits. That is the motivator behind all of this. What the various capitalists want is to break up what they call monopolies. over natural resources and gambling on Native American land. This family and this child are tools that are being used to accomplish this. As the Bracking family produces crocodile tears, lamenting their struggle to keep a child they love, there is an army of bourgeois money behind this, coming for much more than a single child. This infringement upon the Native American community must not be allowed to stand. All power to the land back movement, the real land back movement, not the fake Jeff Bezos one, the real one that existed before Jeff Bezos was even born. Land back, period.
Thank you for watching. If you like this program, then please head over to my Patreon page and set up a monthly donation. It's your donations that keep this program running. Also, if you would like, please rate, comment, subscribe, and share in various social media.